So, Mr. Makhdoom, one thing that we could actually rely on Samiullah Baloch is to clear ourselves as to what declarations we're talking about. So declaration arising out of civil jurisdiction, which is an outcome of civil litigation. So several other declarations which are not arising from civil litigation or civil jurisdiction are out of the picture.
Yes, Baloch.
So ek to wo limit ho gaya na. So one benefit that one could probably draw from Samiullah Baloch is that the nature of that declaration is quite obvious. The second question would be, of course, the duration, but this is quite clear.
And my lord, that immediately leads to two submissions. Your lordship, in my research, I have not been able to find out, but your lordships may be aware better than me, that I could not find a case from any common law jurisdiction where, as a result of a civil liability and a decree of a civil court, a citizen is denied the right to exercise or the protection of a fundamental right guaranteed by the Constitution for the rest of his life. Criminally, in criminal law, it may happen.
About a banking case.
My lord.
How about a banking case?
My lord, yes.
Is declared
My lord, yes.
debtor.
Now, the question is,
The law says that if you're a debtor, till you are a debtor, your disability is there till you clear the debt.
correct, my lord, your lordship is absolutely right, and that is why your lordship will find that insofar as that is concerned, that is reflected in Article 63 of the Constitution, and Article 63 talks about, one, the debt having been outstanding for a particular period of time, and till such time that it is paid. The moment that debt is paid, debt is removed. I was talking of a situation where a civil liability results in a person being deprived of his right forever. Because in this case, my lord, in the case of a debt, as your lordship has rightly identified, or utility bills not being paid, the moment they are paid, the debt is met, the person is eligible. In this case, what does he need?
In this case also they say that
But regulate the fundamental right of political association and action under Article 17.
There it has been, as a consequence, we understand that that person has committed fraud because he came up with a fraudulent sale deed. That is a bit of a construction that we have to do in order to justify this declaration given in the court. Having said that, all the other declarations which are coming in through original jurisdiction and the writ jurisdiction not arising from civil jurisdiction are out of the canvas, right? So let's first specify that the declaration we're talking about is inter partes arising out of civil litigation.
Right.
Now, in the absence of 232, we would have had to construct what is to be done. I'm just saying that legislation could, not justifying 232, but legislation could say that for the purpose of election, such a decree which is arising out of civil litigation could have a time frame for purposes of election. So the question is, can legislation put a time frame on this declaration? Could that be possible? Not the way it's worded in 232. My question to you is that, first of all, Samiullah Baloch helps us identify that which declaratory decrees we talk about, which declarations are relevant. Declarations arising out of civil jurisdiction, which are inter partes, number one. Now, could legislation, not the way it is done today, but could legislation say that this declaration will continue forever between the parties, but for the purposes of election will have a time frame?
My lord,
such a legislation is not the way it is done now in 232, but could such a legislation be possible to say that a declaration inter partes arising out of civil litigation for the purposes of election would only be for 5 years, even though between the parties it will remain forever till it is set aside, but for the purpose of election? Could such legislation take place?
my lord, that was a bit later, but may I address it right now? My lord, when your lordship looks at 62(1)(f), the constitution makers under the 18th amendment do not say that this is a declaration of a civil court. They say no declaration to the contrary by a court of law. A criminal court is as much a court of law as a civil court. Now, if your lordship reads a court of law as a court of law, a court of plenary jurisdiction, that would include courts both on the civil and criminal side which decide cases after recording of evidence. And in that, if your lordship does that, then 63 and 62 will have to be read together. There's no way one can read them differently. My lord, may I just preface this a little further?
Sure.
My lord, a question has been asked and repeatedly that, and my lord, Mr. Yahya Afridi asked that again yesterday.